Hi, besties. If you are wondering if Blake Lively's letter motion yesterday, basically telling the judge, I need more time because you have to deny this because I said so, because for the motion on judgment of pleadings, where Wayfarer is basically trying to get rid of her entire case for the most part. Well, our favorite scorched earth attorney, Kevin Fritz, is back, and he has a knockout response to her, which I'm pretty impressed with. And he goes to the heart off the bat, basically annihilating her arguments. Now, obviously, we don't know how the judge is going to rule in this case, but he has good foundation for these. And I think he makes a good plea to the court. He states that a party is permitted to move for a judgment on pleadings after the pleadings are closed, and that this is available to challenge a plaintiff's failure to state a claim. It's not waived until the close of trial. So it basically can be done at any time, as I've told you. Miss Lively erroneously argues that Wayfarer parties sat on their motion for nearly 9 months, and that adjudicating the motion now would only lead to duplicative briefing and waste judicial resources. Remember how I said she admitted that she amended her complaint? Yeah, they get to that. First, her operative pleading was not filed 9 months ago, but 2 months ago, in response to the court's dismissal of her claims against Jed Wallace and Street Relations. Miss Lively was not obligated to amend her pleadings, but nonetheless chose to file her second amended complaint on July 30th, 2025. When Miss Lively opted to supersede her earlier pleadings with the filing of the second amended complaint on July 30th, she knew that Wayfarer parties were not obligated to file answers for several weeks thereafter, and that upon such filings, and only upon such filings, the Wayfarer parties were entitled to move for a judgment on pleadings, right? So you have to answer it before you can do the judgment on pleadings. Indeed, Miss Lively recognizes at a July 30th hearing in a related proceeding, the Wayfarer parties notified the court that they may seek relief under Rule 12C. If Miss Lively is now unprepared to oppose the motion, the fault lies with her. There was some debate about the CRD because she said that she amended it. And there's a huge problem with that footnote. They don't even touch it because it honestly doesn't matter. Under federal law, in order to sue under Title VII, she has to have an EEOC right to sue notice. Blake's complaint does not attach any of her CRD documents. In order to sue in court, her complaint needs to state either the date that she filed her California CRD to make sure that it's timely, and it needs a copy of it so that the judge can verify that the individuals that are on the right to sue notice match the parties that she's suing. She did neither. In her first complaint that was filed based off the December 20th, 2024, she included It Ends With Us movie without any right to sue them. She did not attach a copy of her CRD complaint, and she also did not copy a federal right to sue notice. She cannot cure it after the fact without notifying the court and seek leave to amend to add the parties. She improperly added It Ends With Us movie from the beginning, and changing it now doesn't change the fact that she didn't exhaust her administrative remedies. I got that all from the CRD. So he tells the court that a judgment on pleading is appropriate where inferences drawn in favor of the non-moving party has failed to allege facts that would give rise to a plausible claim or defense. Here, the motion seeks dismissal based purely on predominantly legal issues. Okay. They say their legal issues are her claims for sexual harassment, retaliation, failure to supervise, and aiding and abetting under California statutes fail for lack of extraterritorial application. And if you go to the CRD, you'll get a letter that says you have a right to sue, which gives you the right to sue in the state of California, or if you go to federal court in California, you have to get a federal right to sue. That letter of her right to sue did not give her permission to sue California claims in New York. Blake, in her motion, tried to tie it together by saying, I have federal claims, that's why I'm here, And then I have California claims that arise from the same issue. So you have jurisdiction over them. That's not enough of an argument for jurisdiction. They also say that she failed to exhaust her administrative remedies with respect to various claims against It Ends With Us movie. She failed to adequately allege retaliation. Miss Lively's defamation claims are barred by litigation and or fair reporting privileges, and she failed to allege an underlying tort supporting her civil conspiracy claims. None of those issues require the court to examine anything other than her second amended complaint and the materials incorporated therein by reference or integral thereto. She does not specify how any of the voluminous evidence that she has uncovered would be properly considered in an opposition to the motion or warrant the denial thereof. Stated differently, there is no need for Miss Lively to scramble to amass evidence from an ongoing discovery to oppose the motion because the motion challenges defects on the face of her own pleadings. Although Miss Lively notes that she may yet again amend her pleadings, she does not explain why she has not done so or why the court should allow any such amendment at this stage of the litigation. She has already been given a second chance, actually a third, because she filed her first complaint, then her first amended complaint, then her second amended complaint, which I said, like, you can't infinitely keep amending your complaint. That's not how it works. And it wouldn't change the fact that the FEHA claims can't be brought to federal court. She's in the wrong court. If the motion is granted in full or in part, any such adjudication will reduce the number of Miss Lively's claims. In turn, and even assuming any part subsequently seeks summary judgment, the case will have been properly streamlined, thereby reducing the amount of briefing and evidentiary submissions on any motion. Thus, judicial resources will be preserved, the very purpose of a Rule 12C motion. So if the judge can rule on the motion on pleadings, judgment on pleadings, before even summary judgment happens, they don't even have to file a summary judgment, is what they're saying, if it's not even needed. And then he goes into the fact that she can't explain that the motion will delay the trial scheduled to commence in March of 26. He reminds them that fact discovery is ongoing. There's no summary judgments that have been filed, and the trial is more than 5 months away. He even provides examples of how courts have granted motions 12C at procedural stages that are far more down the line and in advance than where they are right now. Some have even granted it after parties have moved for summary judgment and after partial summary judgments are granted. I love the fact that she wants an extension of time, because how many times have we discussed that she has filed motions for sanctions and filed all of these documents while discovery was still going on? And whenever Wayfarer tried to request an extension, she would not agree to it. He points out that she and her husband have filed numerous motions for sanctions against the Wayfarer parties and their counsel. And that all happened while discovery was ongoing, right? So she filed so many extra motions against them, and they had to respond to those while they were still dealing with discovery. And now she's trying to say she can't respond to this because she's dealing with discovery. He also notes that granting it would mean the parties would be briefing the motion close in time to the summary judgment deadline before the court has had a chance to narrow the case. The request should be denied. And then he brings up a request of amending the case management plan and the scheduling order. And he said that it's due to the fact that when the judge initially changed the scheduling order on September 9th, he revised expert discovery schedule to provide for completion of discovery on November 14th. But the parties did not pose, and the court did not endorse an adjournment of the current November 5th, 25 deadline for summary judgment. So you're supposed to be doing summary judgment once all of the discovery is closed. You don't do a summary judgment while discovery is still ongoing. And so what he's saying is that you have a date for us to finish these by the time we're still doing expert discovery. He said fact discovery is not expected to be completed until October 10th. Last night, Wayfarer parties proposed revising the case management plan and scheduling order, and they're waiting from Lively to respond, but they're saying that opening reports for the experts would be October 24th. The deadline to exchange expert rebuttal reports would be November 7th. And then deadline to complete depositions of experts would be December 1st and December 15th, 25 deadline to file summary judgment motions. They say that good cause is needed for this because it will provide the court with sufficient time to resolve the motion, give the parties the opportunity to finish fact discovery prior to exchanging opening expert reports, and allow the parties to complete expert discovery prior to the filing of summary judgment motions. Importantly, if the majority of her claims are dismissed via the motion, the proposed schedule will allow the parties and the court to focus on a few remaining claims in connection with any summary judgment motions or trial. Moreover, on September 30th, merely 10 days before the current October 10th deadline for opening expert reports, proffered a new theory of damages. Miss Lively's alleged lost profits computation, and then they share like some information. So she changed at the deadline how she was going to claim damages, and they say now their experts need more time to examine that claim. As long as the trial stays for March 9th, I don't know why this isn't reasonable. And I've told you a million times how tight all of this is. And you cannot file a summary judgment when discovery is still open. So I don't see why this wouldn't be agreeable. The only thing I can see is that Blake will not agree for whatever reason, but this benefits everyone. And they also note, this is hilarious, the request for admit. So you have to, before you do summary judgments and before you get to trial, you have to settle and agree what the facts are of the case. And so you have to get people to admit certain statements. And according to Kevin, the requests would be and are supposed to be served by August 14th. In the parties' joint request to revive part of the scheduling order, no request was made to extend the deadline and no extension was ordered. Months after learning the deadline and 6 weeks after the deadline has passed, she seeks to extend the expired deadline. However, Ms. Lively fails to explain why she did not serve requests to admit by the deadline or why the existence of future depositions prevented her from serving requests, especially given the purpose of requests to admit is to narrow factual issues. So he wants her to be denied for failure to demonstrate good cause for the proposed amendment. It's wild that she missed a deadline. Think of all the times Blake has run to this court and said that Wayfair's late, they're stonewalling, that they haven't provided stuff. And here we find out that she was supposed to provide her request to admit on August 14th and she never did. And then she seeks relief after the fact. She has a lot of really high-powered attorneys, and I don't think they have client control here. And I also don't think they're being honest with her. I can't believe an attorney that is an experienced attorney in litigation and employment law would even think to file their case without the proper right to sue from the federal government, without attaching to the complaint a right to sue notice. And by the way, thus far, Blake Lively has never provided a letter to the court to prove she has the right to sue. All Wayfair has to do is show the court that when she initially filed this lawsuit, It Ends With Us movie was not included in the right to sue. And once you sue based on the right to sue notice you get, that's your chance, right? Amending it and adding someone after the fact doesn't cure the issue because the claims were made off the right to sue, and that litigation you started, you told the court was based off that. And if you effed that part up, you don't get to run back and say, oh, just kidding. And if you do change it, you have to tell the employer. The California right to sue letter states that it's your requirement to serve notice on the employer. So if she cured it and got a new right to sue, she was supposed to tell Wayfair and she was supposed to tell the court, but she didn't, which is why Wayfair is ignoring that part of it. And I've said for a long time that these claims were dead on arrival from the day she filed this claim because of how she messed up the steps with the CRD and the EEOC. And I don't know at what point they're going to bring up the EEOC issue. Perhaps Blake hasn't even shared with them that she has a right to sue from the EEOC. Because if the EEOC hasn't given her a right to sue and she's suing right now, and to be clear, her current letter for California states that she needs to file a charge with the EEOC herself. It states she needs to get that. She didn't do a dual filing or cross complaint, which she can do, but she chose not to. And her right to sue says if you're going to go federally, you need to go to the EEOC within 30 days of this letter or 300 days of the last instant of sexual harassment. She never went to the EEOC because she knew she couldn't, because the last reported incident she claims was in May of 23, and she was well past the 300 days at that point. She's been time barred from the beginning, and she's just mad that they're now getting rid of this, and they've known this the whole time, right? And even if they sat on it the whole time, they didn't have time to do this until she again decided to amend her complaint. It's so dumb. And they could have waited to do it after her second amended complaint simply because after August of 2024, more than 300 days has passed since she claims any retaliation happens, and they're in the clear. So they could have just waited strategically too. But she's the one, again, that chose to amend her second amended complaint. So basically, what Wayfair is telling the judge is all of these issues that she's bringing you are her own self inflicted choices. It's her fault that everything is scrambling right now because she chose to do her second amended complaint in August. She knew that we were going to respond. We told her we might file this, and now she's crying to you. I really hope the judge gets this one right and doesn't like talk over them, but there is a hearing scheduled for tomorrow on this very topic. So I will be listening in and I'll let you know and I'll get back to you when it is done. I doubt he will make a ruling at the hearing. He'll likely take it under advisement. So tell me what your thoughts are in the comments below and let me know. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and please click the bell so you never miss a video. Thanks so much for watching. Bye, besties.